great state of Florida in this honorable court.
Please be seated. Welcome to the First District Court of Appeal. As this judge understands the docket today, we have two cases. The first case is State Farm Mutual Insurance Company versus Florida Department of Revenue. And counsel for the appellant, are you prepared to proceed?
Yes, Your Honor.
All right. You are Mr. Cox?
Mr. Kevin Cox, sir.
And we have Mr. Cox on the other side.
Yes,
the
Your Honor.
marshal did alert me to that, so that'll be easy for the court to remember the participants. Would you like to reserve any time for rebuttal?
Yes, Your Honor. 4 minutes of rebuttal, please.
So noted. You may proceed.
May it please the court. Again, I'm Kevin Cox here on behalf of Appellant State Farm and certain of its affiliates. The positions of each side have been briefed at length, and so I think in light of that, the best way to begin this is to make three really critical points. One is what the statute at issue says. Two is how its language and structure shows what it is intended to accomplish. And third, what that means for this case. The relevant Florida statute, section 220.131A, and it says, among other things, that Florida taxable income for the Florida corporate income tax is calculated by adding to federal taxable income the following. And I will ask to your indulgence. I'm going to read this statute. It's about a paragraph, but it's important to understanding where we go from here. There shall be added to such taxable income the amount of interest which is excluded from taxable income under section 103A of the Internal Revenue Code or any other federal law, less the associated expenses disallowed in the computation of taxable income under section 265 of the Internal Revenue Code or any other law, excluding 60% of any amounts included in the alternative minimum taxable income as defined in section 55B2 of the Internal Revenue Code if the taxpayer pays tax under section 220.113. That's a lot of words and technical references, but I want to try to simplify and just explain where I think that leads. The Florida corporate income tax uses federal income tax as taxable income, as the starting point. In other words, the Florida law piggybacks on that federal taxable income as the starting point.
So if it piggybacks, doesn't the word exclude have a particular meaning as it does in the Internal Revenue Code?
So the word exclude is interesting here, and the department has argued that exclude must mean only what section 103 means it to mean, that it's an exclusion, meaning it is not included in gross income. It is never part of gross income. But here, the only way to both strictly and I think apply the logic of the Florida statute is to read that it is exclude basically means it is not included in. This is a critical point.
That's my question is more particular than that. I'm not asking whether it's intended to mean 103. I mean excludable as opposed to deductible.
So we know from the
Florida statute in other subsections or subparagraphs mentions deductible or amounts that are deductible. So the legislature clearly knows the difference between deductible and excludable, but with this particular provision, it specifically says excluded, and it makes a reference to 103, which expressly mentions excludable under certain circumstances that don't actually apply to insurance companies. But.
Sure. And if the court is persuaded by that analysis, I would submit that there is no tax-exempt interest that is excluded from a property and casualty insurer's federal taxable income. State Farm is not asking.
Why isn't it 100% then?
Why isn't it 100%?
Yeah, if what you said is true, why isn't it 100% and not 15%?
Because gross income for a property and casualty insurer actually includes all. And there is no exclusion of federal taxable income for a property and casualty insurer. All of that under Section 832 is actually included in gross income. It's the deduction that occurs after through 832C7 to the with respect to the amount that would be excludable under Section 103 for any other kind of company. So if we take a really strict definition of exclude, then there is no tax exempt interest which is excluded from a property and casualty.
I think the question is well, why isn't State Farm actually? Why should any of the what we would call exempt income, the state and local bond interest? Why is State Farm? Why should any of that be added back to State Farm's income for purposes of state taxation?
So I can speak for State Farm. I can't speak for the others, although there is an amicus brief. I don't think that's a reasonable, anybody would read that as the reasonable meaning that somehow property and casualty insurers should read exclude to mean they don't have to pay, they don't have to add back that tax exempt interest. State Farm's position is State Farm should pay 100% of tax exempt interest, no more, no less.
But it's not exempt for State Farm.
I'm sorry?
But it's not exempt for insurance companies, is it? I mean, what is the basis for saying that it's tax exempt for insurance companies under Subchapter L?
Sure. So for a property and casualty insurer, Section 832 makes clear that gross income includes that it includes interest income, which is part of investment income. It adds up into gross income. It is part of gross income. Right. And then it deducts that tax-exempt interest income as part of the calculation to go from gross income to federal taxable income. Sure. And it says the deduction is consistent with what would be excludable under Section 103.
For everyone else, except
for everyone else.
Right. So I guess, is there anywhere else in the Internal Revenue Code where a deduction or allowable deduction is considered tax exempt?
Where an allowable deduction is considered tax exempt. So I'm not sure if I can answer your question, Your Honor.
I know there's a lot of sections in the Internal Revenue Code, so it's maybe not entirely fair. But my point is, I guess your position is it's still tax exempt, even though it's not exempt for insurance companies, and I'm trying to understand why. To me, it seems like tax exempt it refers to things that are excludable from income.
Sure. Well, in this instance, I think the Department agrees in its own briefing that the 832C7 deduction is what effects the same policy of the Section 103 exclusion. It's not technically an exclusion, but I think even the Department agrees that accomplishes the same principle, which is that the federal tax code doesn't want to tax any company's interest on state and local bonds.
Right, but we're charged with applying state law here, and
yes.
So we're trying to figure out what the Florida statute at stake is here. And so regardless of what the industry might think it means, if we're looking at a statute that says you have to add back in amounts that are excludable or excluded from income, shouldn't we be looking at what is actually excluded from income under the Internal Revenue Code and not looking at things that are deductible?
I think that would lead to the result that State Farm would pay nothing, because nothing is excluded under that definition. I think State Farm's position is that Section 832C7 still, that deduction, even though it doesn't use the word deduction here, that's the principle that it's trying. I think this is not trying to read words into the statute that aren't here, but trying to read in harmony the Florida statute and the federal statutes that it's relying on. Because Section 103 for any other kind of company would simply be an exclusion. That would be a very simple analysis, and you would just add back 100%. Here, the problem is that the federal tax code and governs the general here. 832, I think, governs 103 and how you interpret 103. The department cited the Barnett Banks case for that same principle. I think 832, you have to read what does that mean? How is it achieving the policy under Section 103? It's achieving it through a deduction, and that's why State Farm believes that it still does need to pay Florida corporate income tax on its otherwise tax-exempt interest, but just 100% of it, not 115%.
Appley claims that your argument conflates or confuses investment income from underwriting income, and I think there's merit to that argument. Can you address that, please?
Certainly. So underwriting income and investment income are added together to create gross income at the federal level. And then a series of deductions occur to get to federal taxable income. So, and they are all happening under Section 832, so which would qualify as any other federal law under the Florida statute that we were just talking about. So the fact that part of that occurs through a deduction, 100% of what would otherwise be excludable under Section 103 occurs as a deduction under 832C7, and that another part in that same statute occurs in the calculation of underwriting income. That's under 832B5B. Both relate to interest, both on these state and local bonds. Both are adjustments that are happening in different parts of Section 832, and it makes more sense to do the adjustment for the 15% proration, as the legislative history describes it, on the underwriting income side. But the main point is that both of those adjustments, both of those all happen before you get to federal taxable income. And the only quantity that the state statute references is federal taxable income. And the only item that the state statute wants you to look at is federal taxable income. Both of those adjustments to interest happen before you get there, and you really need to consider both, even though one is related to investment income and one is related to the calculation of underwriting income.
How does the loss deduction work? So looking at 832C4 on the one hand and the definition of underwriting income under A3. So underwriting income as defined is added as part of the gross income that the insurance company takes in, right?
That is correct.
Okay, but to figure out your underwriting income, you take your premiums and subtract losses incurred, as defined under whatever it is. A5,
losses incurred,
right?
Which includes paid losses as well as
Right.
discount or change in reserves that are for
Sure.
unpaid
But then
losses.
actually then adjusted by this 15%.
That's correct.
So then you have your gross income on the one hand, and then when you figure out the deduction, it says you can take your losses incurred as a deduction. How is that not a double deduction? So your income has been reduced by your losses incurred on the one side, and then you get to take a deduction for losses incurred on the other side. It seems like you get to take a deduction. I have a reason for asking. I'm just trying to understand structurally, because you're arguing, you have this extra 15% that have been added back, but I'm trying to calculate how that works. It seems like you're
I
taking
see your
deductions
question,
twice.
and my understanding is that the way that is applied is not that you, it really wouldn't matter. Let's assume that you were deducting it under later from gross income. I think you get to the same result. The point is that federal taxable income is all below that line, below all those calculations. But I think the way it is typically applied is that underwriting income, and this comes from the accounting statements, the underwriting income is calculated by taking out those losses incurred based on those adjustments. I can't fully.
But then you don't take a deduction after you figure all that out for the losses incurred later, like you would with the interest income?
So it is part of the underwriting income calculation, and I think that's normally how they treat it in terms of. I don't think it matters, but that's my understanding, and that's State Farm's position on how they would normally treat that losses incurred deduction. And I see I'm well into my rebuttal time. I'm happy to answer anything, but it might be a good time to sit down too.
Well, Mr. Cox, we may have a couple more questions for you now that we've been asking questions. I will restore that 4 minutes, though, because you were asked questions into your rebuttal time. So, Judge Tannenbaum, did you have another question?
Yeah, so going back to an earlier question I asked, so you reduce, this is looking at, what is it, A5B, the reduction of the deduction for losses incurred, which is the heart of your, I think, your position. you're making the assumption again that tax-exempt interest under I includes this state and local bond interest?
That's correct.
And so how, I guess it seems important. I don't understand how you get there. Like, why is it considered tax exempt for insurance companies when it's not excluded from income?
Sure. Well, the language is, I mean, we don't take the position that 103 has no role to play here. 103
But
doesn't
how
do
does it play a role? Because it's in an earlier subchapter. You have in section 11B that says that this stuff doesn't apply for insurance companies. Look to subchapter L, which seems self-contained and completely, you just look to subchapter L to figure out everything for an insurance company. So why would we look at 103 for anything other than where it tells us expressly, which is later on in the deductions?
Sure. So our position is that 103 is incorporated to help inform the way that 832C7 or anything in 832 will look at that tax interest on state and local bonds. 832C7 uses Section 103 to define the scope of that deduction. And for any other taxpayer, as we discussed, that would be the policy is not to tax them. And so,
but it's not exempt for insurance companies, is it?
It is exempt in the sense that 832C7 recognizes that this is what you're doing is deducting what would be excludable under 103. And I think that accomplishes, and even the department has said that this is affecting the same policy. I mean, this is...
So State Farm really wants to give the state some money. It just not everything. Is kind of
just the
position.
same amount that any other type of company would be, which is 100% as opposed to 15. And State Farm doesn't take the position that it's not excludable. It's not 103, therefore we only have to pay 15% or 0%. State Farm just believes that you should only add back the portion to capture what was not actually included in your federal taxable income. And in this instance, that's 85% because 15% is included in your federal taxable income.
All right, Mr. Cox. Madam Clerk, we will give the appellant 4 minutes for rebuttal. We will add 4 minutes to the appellee's time.
Thank you, Your Honor.
If you are so inclined to use it. Mr. Cox, please proceed.
It's always risky business.
I don't need it. Thank you, Your Honor. May it please the Court, I'm Clifton Cox, Special Counsel for the Attorney General, and I represent the Appellee Department of Revenue. The formula in Section 832B5 computes a proxy by multiplying 15% by the sum of three amounts: the amount of interest on state and local bonds, the amount of dividends received, and the increase in policy values.
How do you get to the first part?
I'm sorry?
How do you get to the first part? I mean, that's the state and local interest on bonds does not appear in,
Well,
in that
tax-exempt
provision.
interest
Yeah.
is defined in Section 103A.
Right, which doesn't
And
apply to
then-
insurance companies.
But the other two statutes that are involved here, Section 832C7 and 832C4, provide for deductions or exclusions of the amount of interest that is excluded from gross income by Section 103A.
So you don't agree that exclusion and deduction have distinct and separate meanings?
Your Honor, I have my master's in tax. Under federal law,
And I do not. So
the federal tax code sometimes uses terms very precisely. Now, we have the benefit of Florida statutes, Section 220.13(1)(a)(2), where the Florida legislature directed that Section 103A was incorporated by reference and was deemed to provide an exclusion from taxable income. Now, actually, the language in Section 103A refers to gross income. Now, the Florida legislature was correct in that taxable income is a subset of gross income. So something that is excluded from gross income, just by definition, is also excluded from taxable income. So federal law specifically excludes, whether it's by deduction or exclusion, the effect, as Mr. Cox stated, would be the same in that particular context. But federal law would exclude all tax-exempt interest, defined as interest on state and local bonds, from gross income and therefore from taxable income. But the tax-exempt interest is one of the three elements used to compute the proxy, which is simply a mathematical value that's used to reduce a deduction. So the court should affirm the decision below because Section 103A, which is incorporated by Section 220.13(1)(a)(2), 832C7, and 834C1, directs that all tax-exempt interest is excluded from federal taxable income, gross income, and therefore taxable income. And so therefore the Florida statute, Section 220.13(1)(a)(2), would require that same amount to be included in Florida taxable income.
Well, it seems like the department is trying to have it both ways with that interpretation. So on the one hand, if you're going to take the more, what I would consider to be a technical approach, it's just layperson, it seems to me that excludable and deductible mean different things because it's used different ways, and even Florida statutes use both terms, and they seem to have particular meanings. So on the one hand, if it needs to be excludable or excluded from income pursuant to 103, and insurance companies don't have that interest income excluded from their income pursuant to 103, then you can't say that State Farm had any of their interest excluded from their income because it didn't happen. On the other hand, if you take your more, I guess, practical approach or loose approach to the terms and say, well, it really doesn't matter what the terms actually mean, it's the effect that matters. Okay, well, why can't we then look at whether, in fact, State Farm saw 100% of their bond interest removed from the calculation of their income? And their chart on page 6 of their initial brief, again, for a layperson, it seems like, well, it looks like they didn't have 100% of their interest taken out of the calculation.
Your Honor, I believe that you asked about three questions.
Great.
And I'll try to do my best to answer them in that order. Unless I forget the third by the time I finish my second.
That's okay.
If you look at the tax return, which is part of the confidential filing, Schedule A of State Farm's tax return, which is the Form 1120 PC for, I believe it's the 2013 year, shows on Schedule A, line 3A, total interest. Line 3B, tax-exempt interest. Line 3D, taxable interest. State Farm deducted 100% of the tax-exempt interest and was only taxed on the taxable interest. The problem here, Your Honor, is the proxy, and whether one element of the proxy, the tax-exempt interest component, which is then added to the other elements, multiplied by 15% to create a proxy used to reduce a deduction, well, you're right, Your Honor. Economically, that 15% affected their tax. But in tax issues, as the United States Supreme Court and the 11th Circuit have explained, in the Seminole Tribe case, and also in the federal case that we cited, tax law is unique. The economic consequences of the statutes do not govern tax cases, tax disputes, when the legislature states its intent. the legislature, the Florida legislature in section 220.131A2 specifically directed that the tax-exempt interest that is identified in section 103A, that is added back. And so whether you're dealing with 220.131A2, 832C7, 834C1, all of them refer back to the amount of interest that is excluded from gross income under Section 103A of the Internal Revenue Code. And the Florida legislature directed us to read that exclusion from gross income to mean an exclusion from taxable income. Now, Your Honor, I believe Judge Tannenbaum asked essentially, why is there this reduction of a deduction, this convoluted mess? Well, the Congress realized that insurance companies, property and casualty insurance companies, receive a double tax benefit by using tax-exempt interest to fund another deductible expense, the amount of what they have to reserve for losses. Now, Congress could have said that all of this is taxable so that you don't receive any benefit, but instead they use this reduction of a deduction to reduce the double tax benefit that property and casualty insurance companies receive.
And to figure that out, they use the amount of state and local bond interest, right?
Yes, Your Honor.
Okay, so overall, and look, I was happy to just go with the technical terms, but it was, I think it's the department and apparently State Farm that want to take the more practical effect approach to these terms. So, but if you're going to live by the effect approach, like it doesn't matter whether it's a deduction or an exemption. If it's pulled out of their income, then it has to be added back in for purposes of taxation or the statute. Isn't it not true, based on what you've said, that their income before deductions, even when they're calculating, a premium with the or the underwriting income, that number goes up when they add the 15% back in to their losses incurred, which means that their taxable income goes back up a proportional amount compared to the amount of interest that they earned on their state and local bonds.
One analogy we can use is that of a smoothie in which you put strawberries, blueberries, and banana, mix it all up, then pour out 15%. You really can't identify those three different components. When Congress and the Florida legislature declare that the full amount of this tax-exempt interest, whether you use that short form that I prefer so I don't get my tongue twisted, or interest on state and local bonds, none of that is deemed taxable by the Florida legislature, which directly referred us back to 103, or Congress. So economically, as we have acknowledged in the brief, the economic effect of this reduction of a deduction would be an increase in the taxable amount. However, Congress declared that none of that is deemed part of federal taxable income. And so that's why the real problem here is, do we rely just on the economic consequences or follow the Supreme Court in Chickasaw Nation and 11th Circuit and Seminole Tribe and look at what the text of the statute says as to what is being taxed? In those two Indian tax cases.
But if you look at the text of the statute, again, back to Judge Tannenbaum's questions, you have deduction for State Farm, and the Florida statute talks in terms of exempted income. So, I mean, again, to take a originalist, textualist look at these words, they're different, aren't they?
Yes, Your Honor, as are the words referring to taxable income in Section 220.13182, which incorporates 103A's statement of exemption from gross income. And that makes sometimes these statutory issues difficult for everyone to understand. But when you look back at the legislative intent,
Well, the legislative intent, the best indicator of that are the words.
Yes, Your Honor.
Is the words the legislature has chosen.
and we're not relying on any legislative history for that very reason. The legislature said...
And the legislature used the word exempted, not deducted, correct?
Well, the legislature, the statute in Florida says the amount of interest which is excluded from taxable income under Section 103A of the Internal Revenue Code or any other federal law. The only three statutes we have identified in the Internal Revenue Code that would effectively exclude tax-exempt interest would be those three we cited: 832C7, 834C1, and 103A.
But there you are again, Mr. Cox, effectively excluded.
Yes, Your Honor.
But what we have here is a deduction, correct? You would agree with that?
Yes, Your Honor. And so,
Would you also agree, and I believe Judge Tannenbaum said it in passing, that 103A does not apply to property and casualty insurance companies, but for B7? I mean, 103...
C7, 832C7, and 834C1.
But before you get to those, 103A does not apply to property and casualty insurance companies.
Your Honor, that, I believe, is the consensus. However, it's not the universal consensus.
But it is the effect of Section 11B.
I want to hear
the consensus.
I want to hear your consensus. Where does that come from? I mean, does that come from the text or
Yes, Your Honor.
this anecdote? Okay.
From the text.
All right.
Because in Section 103B, we have the only exclusions, the only exemptions from that absolute exclusion in 103A. Those three do not apply. Arbitrage bonds, for example. There's no claim that that's what this is. And other provisions of that same subchapter in which 103A and 103B are located, other provisions of that also apply directly to property and casualty insurance companies. So, Your Honor, based on the text, there is a very strong argument that can be made it does apply directly. However, if we apply it that way, it seems a bit redundant to have it excluded in 103A and also to look back from 832 and 834. So that's why the consensus is that 103 applies indirectly through 832 and 834 and is incorporated by Florida Statutes 220.13182.
Congress easily could have just said under subchapter L something similar to what 103 says, which is that for
Yes,
insurance
sir.
companies, it could have been in, well, heck, I mean, they could have put it in B1 somewhere, that gross income, excluded from gross income, is state and local interest on bonds, right?
There are so many ways that Congress could have drafted the statutes differently,
Right.
as
But they
could
did
the Florida
not.
legislature. For example, Congress could have said in 103 that 85% of the interest is excluded from gross income, but Congress didn't. Congress could have said in Section 832C7 the same thing, that 85% of the interest is deductible or excludable through a deduction. But it didn't. Instead, the text of the statutes says that the entire amount of the tax-exempt interest that's excludable under Section 103A is deductible by property and casualty insurance companies. So Congress directed that all of that, 100% of the interest, is deducted or excluded from computation of taxable income, even though a computation of a deduction would indirectly use that as one of the factors.
But it can't be an accident that Congress chose to do it the way it did it. There has to be a reason, known only to Congress, as to why it's a deduction and not an exclusion. But isn't the practical effect of the difference between a deduction and exclusion? An exclusion means when you're doing this calculation, you just don't include it. You don't have the option. A deduction isn't, when it says it's allowable as a deduction, doesn't that make it the option of the taxpayer to include it or not include it?
No, Your Honor. And let me go back to answer a previous question. The National Association of Insurance Commissioners, or NAIC, produces annual statement forms that all of the carriers have to submit to the local OIR and also to the taxing authorities. So this approach to excluding it by means of a deduction would make the tax forms consistent with the NAIC annual statements, the tax that the companies must follow. So I think that is the only reason that I can conceive as to why it was structured in this peculiar way, because of the form of the NAIC's annual statement. So we submit the court should affirm the decision below, because sections 103A, 832C7, 834C1 direct that all of the tax-exempt interest is excluded. So Florida statute section 220.13(1)(a)(2) requires that full amount to be included in Florida taxable income.
Isn't it possible that the legislature just had in mind when it wrote 220.13 1A2, it just had in mind generally corporations? I mean, most corporations, this isn't an issue. 103 is going to apply. It's excluded from their income. Not a big deal. Isn't it possible the legislature wrote this provision with all the other corporations in mind, and either as an oversight or something else just chose not to address the unique circumstances of insurance companies other than their specific definition of taxable income at the end of the statute?
Your Honor, I wish we could find legislative history explaining the analysis of the legislature. But I don't believe that either side has identified anything clarifying the thought processes of the legislature in structuring this as it did. I wish I knew, Your Honor.
Okay.
If there are no other questions, I thank you.
Thank you, Mr. Cox. Rebuttal?
Yes, Your Honor. A few points. There is a lot of discussion about what excluded means under Section 220.13. I would submit that if the court believes there's two alternative meanings, one is just whether it's included or not, and two, whether it's a specific meaning under, it can only be under a Section 103 exclusion, that there is ambiguity. And our position has always been that it's clear, and this is our approach, but if there is ambiguity, then the inferences are drawn against the tax collecting authority. And we've cited that Miller versus Agrico case, page 57 of our brief. I think there's a lot of other cases that support the same. And that would result in a decision in our favor. As we agree with the department that a lot of these tax peculiarities are a direct result of the NAIC in the accounting statements that are required, including things like underwriting income and investment income. These all come straight out of those accounting forms. And as we quoted Judge Easterbrook at the beginning of our reply, Section 832 is no ordinary rule because insurance companies are different businesses. They take revenue in first and then pay out, and there's all these counterintuitive flips that you don't expect from normal companies. And that is, I think, what's happening here. In terms of what do we know about the legislative intent? I think I heard somewhere that the best evidence we have of legislative intent is the language of the statute. And if you go back to where we started with that very long, we focused on really the first phrase of that statute throughout the argument, that very long statute which says excluded under Section 103 or any other federal law, less associated disallowed expenses under Section 265 or any other law, excluding some alternative minimum tax information. I just think this shows you exactly what the legislature intended, our legislature, when it was trying to figure out and be cognizant of the fact that there may be unique provisions within federal law that hadn't even been developed yet or may exist at the time for peculiar industries, and they needed to build in these safeguards so that you weren't limited to just adding back 100% of interest on state and local bonds, but rather saying excluded under Section 103 or any other federal law. Or, if I heard the Department's argument correct here, if you treat this merely as a formula, as a reduction to an expense, that's a disallowed expense associated with tax-exempt interest. We don't think that's the best reading of the rule of the statute, but if that's the Department's position, and I think the Circuit Court's order was consistent with that, then this becomes, regardless of whether it's excluded, this becomes tax-exempt interest. This becomes a disallowed associated expense on that 832B5B, which in effect puts 15% back in our federal taxable income, which means that when we add back 100%, we're paying too much. Either way, whether you use the first clause, which we think is the best reading, or the second clause, we still should get back to what the legislature intended, which was that we don't get double taxed.
Who bears the burden of mistake by the legislature? Let's assume this is an oversight, like I was saying at the end of the other argument. Let's say the legislature just missed it. They had in mind we're going to tax corporations, we want to get back that interest that's excluded under 103, and someone just missed the reading. Who bears the burden of that mistake? Should we just read the statute the way, it sounds like both of you want us to do it, notwithstanding what the text says, just to get to that result? Or should it be, hey, that's on the legislature, and if they want to change it, let them do it, just like Congress did. Congress created a completely different subchapter for insurance companies. The legislature is not. So who bears that burden?
That's why I think that inference against the tax collecting authority in the event of ambiguity occurs. Because sometimes the legislature maybe just never thought of it. We think they did think of, like, there could be other ways and things, but let's assume they never thought about how this would apply to an insurance company. And so it was just unintended language. And so I think that's exactly why you would have an ambiguity. And and that's why the inference should go against the tax collector. And if the legislature wanted to fix it later, they could. But because the fact that they could fix it later to fix the ambiguity doesn't mean that the ruling should go against the taxpayer at this point.
Thank you, Mr. Cox. It was well presented on both sides.
Thank you, Your Honor.
If you would wait for them to clear out before you come forward for our next case. Our second case this morning is Dr. Christina Palin versus Florida Department of Health. Is the appellant ready to proceed?
Yes, Your Honor.
You may proceed. Any time for rebuttal?
Yes, Your Honor. I would like 4 minutes for rebuttal. Should be fine. Thank you. Good morning, Your Honors. My name is Eric Husby. I am here appearing on behalf of the plaintiff appellant, Dr. Christina Palin. And we are here before you today on Dr. Palin's case, which was initiated as Palin versus Department of Health.
Initially, let me interrupt you and ask the question, why wasn't the AG's office notified since there's a constitutional issue raised?
Yes, Your Honor, we received the court's order on Friday, and I do extend apologies that this has occurred. I looked into the matter, and I also reached out to communicate with opposing counsel. Dr. Palin was handling the case pro se throughout the course of the underlying proceedings and even into the appeal, filing the brief on appeal. And I came in for the reply and to prepare oral argument. The AG's office was notified in, I believe it was 2019, under in the context of the original case.
The second DCA case?
Pardon?
Second DCA case?
No, the underlying civil case in this case. And at that point, I believe the AG did not, as I look back, and did not obviously participate. Then Dr. Palin took the instant appeal, and my understanding is she relied on that particular notice as having.
Well, based on your argument that collateral estoppel doesn't bar your arguments here, that means you're raising new argument. So if it's your position, a new argument's been raised, and this is your initial constitutional challenge, the AG's office should have been notified for this case.
Dr. Palin raised the same arguments that we're raising on appeal in the underlying petition in this case, or Palin versus Department.
Well, and I want to make sure I understand as well. I think I heard you just say that the AG's office was notified related to the underlying proceedings in this case?
I believe in this case, yes.
Okay, so the AG's office was notified in this case related to these facts?
Yes, but not
In the underlying case?
Not in the appeal, in the circuit court from which we're appealing now. And I do apologize for that. We did reach out to the AG's office as well on Friday to determine how they would like to proceed, as well as opposing counsel. And I believe based on the court's order, there was a 10-day time period to respond, both on the part of the AG and our side. I don't believe we would have any sort of objection to their involvement, but I believe Dr. Palin also was of the understanding that the attorneys of record, and this was prior to the filing of the appeal, but that the attorneys of record were identifying themselves as assistant AG attorneys or had some relationship with the Attorney General's office. So that was an error, and we do apologize, but here we are.
Now, was the Attorney General notified in the underlying case because it's a Chapter 86 proceeding and the statute actually requires that notice
Yes,
in the
I
trial
believe-
court as opposed to the appellate rule?
I don't recall the specifics of the notice, but I reviewed our records and saw that in 2019 there was a notification sent to the AG's office. Now, I hope I'm correct on all these details. I believe it was in the underlying case in this case.
And
that's
you
why
understand Judge Thomas's point, if it was in the other case, that would be a real issue for
Sure.
you. But if it was this case, then that would be consistent with
Yes.
the argument you're making
Yes,
here today.
it is this case, the circuit court, which entered the order granting summary judgment in this case. Not the other case involved a separate action commenced by Dr. Palin regarding the informal hearing officer's ruling that the conviction in play barred her for 10 years. And that went up to the second DCA, which ultimately ruled against her but stated it could not take any action with regard to the statute itself, absent a successful constitutional challenge, which had not actually been presented in that particular case.
Well, I think that's subject to debate, but I think we'll get into that.
So, perhaps so, yes.
But the underlying proceeding is a Chapter 86 proceeding, right? It's declaratory judgment is what she was
In this
seeking?
case,
Yeah.
yes, a constitutional challenge and declaratory judgment.
Right. And what is the right that she was in doubt about that she was asking the trial court to determine?
Oh, you mean the constitutional right at issue?
Well, that's what the DJA is there for, is if she's in doubt about her rights or immunities or something, and she wants to have a determination of what her rights are.
Yes,
So what
certainly.
was that
What
she
we're
seeking?
referring to is due process, Your Honor, both due process and, as laid out in our brief, there's a section regarding the fundamental rights at issue, And Dr. Palin raised the issue of the right to practice medicine being a fundamental and important right.
Where does
in the
that
state.
right come from?
Pardon?
What is the origin of that? Is that from the state of nature? I mean, the right to practice medicine, where is that?
Your Honor, I don't have a specific answer for where that particular right comes from, but it's a right that's acknowledged in the case law cited in our.
Well, no, you have a property interest in your license.
Yes.
Right? But her license expired by operation of statute, just like it's a 2-year license typically, right?
Now,
And you have to renew?
In this case, Your Honor, Dr. Palin was, just bullet point the facts. We have, Dr. Palin was convicted in August of 2014 of a charge of obtaining a prescription. And that was ultimately triggered a disciplinary process where under.
Right, and her license was
the section,
suspended
yeah,
for a
and then
period of time.
There was a full evidentiary hearing, witnesses and an administrative law judge rendering a decision. She was suspended temporarily for 2 years, which at that point was only about a month away from being the 2 years, which was basically time served, for lack of a better word. And she was then reinstated to the practice of law after that suspension expired. So, not law, I'm sorry, medicine. And so for a period of about a month, she was eligible to practice. And there was no public interest in keeping her from practice, obviously, because the suspension had expired and she was able to practice. Then renewal came up, and that's where statute 8.
Right. What do you think the purpose? What does renewal mean? So what happens if you don't submit an application for renewal? What happens to your license?
Your license will not be renewed. It will expire.
It expires,
Yes.
right? Because it's a 2-year license.
Yes, I believe it's 3, but
Or let's say 2, 3,
either
whatever it is.
whatever
right?
it is, whatever.
There is a time limit on that license.
Correct.
So is it your position that every person has a right, a property interest in having their license renewed, regardless of whether they meet the statutory qualifications for that?
I think it's our position, Your Honor, that all people have a due process right and that all people have a property right and the case law that we cited indicates that there's a property right in the privilege to practice medicine in the state
Right, but
of
due
Florida.
process doesn't exist in the ether by itself. Due process only is attached to the deprivation of a property interest, a liberty interest, or life.
Yeah, the substantive element, and of course we have the procedural element, which also factors in. But yes, Your Honor, we're asserting it as a property right under the due process.
So you're saying that she has a property interest in renewal of her license?
Yes, in this case, Your Honor, we do.
And how is that? Like, can you walk us through, like, where does that property interest come from?
Well, Your Honor,
In the renewal of her license?
yeah, well, she had, because in this case, there was no basis for revoking or suspending her license further than what was done and decided by the administrative law judge. So here, under any normal circumstance, there would be a right to renewal. There was no grounds other than this same conviction, which was before the administrative law judge and decided that under the grounds and under the standards applied for discipline, only a 2-year suspension was warranted. And then step forward to the renewal, and you have the rug pulled out from under the administrative law judge, who made this determination, said, no, your 2-year suspension is inaccurate. Really, what it should be is 10 years. So we're not going to allow her to renew or practice medicine for 10 years based on the exact same conviction that was in play at the administrative law. So there we have it. We believe that's a substantive due process issue, both impinging her right to practice medicine, which had already been reinstated, and now it's being taken away for the same reason
Well,
as she was originally.
how is that different from the argument you asserted in the second DCA, who found in their opinion that it's a bifurcated process, separate and distinct? You've got disciplinary and then licensure.
Well, we don't, I believe the appellee argues these are separate and distinct, but these are, this procedure should be read together as implicating a physician and her right to practice medicine. There should be no ability to non-renew a physician's license based on the same conduct or the same conviction in this case, in this statute, it's always a conviction or a plea, that caused her to be suspended in the first place. Otherwise, this statute is essentially vitiating the entire process. Dr. Palin, who maintained her innocence on the conviction in play here, as a matter of fact, is still up on post-conviction reasons before the Court of Appeals. She still maintains her innocence and is attempting to correct the error
We
that
get the
occurred.
timeline, but, you know, we're kind of back to this collateral estoppel issue where you're the appellant, it's your burden to come in and convince us this is a separate action that has not already been litigated.
Yes,
So we're left, correct me if I'm wrong, but we're left with looking to the second DCA opinion and speculating if there's, you know, we're looking just at the four corners of that opinion. That's all we have. There was no appendix filed that included the briefs that were filed in the second DCA, which would have assisted us greatly, but they were not filed. So do you agree with me that we are here today and our sole focus can be the four corners of that second DCA opinion, period?
The four corners of the second DCA opinion.
That's right. When we're looking at collateral estoppel, has this already been litigated? Is this over? The second DCA, you raised the same arguments or not? But the only thing that we have to look at is the second DCA opinion, and it's your burden to show us why it's different.
Well, Your Honor, I will put it this way. I think that this appeal concerns the lower court's order, the Leon County Circuit Court's order granting summary judgment. And as we know, this order was prepared by respondent counsel at the direction of the court after a hearing at which the judge did not make a single ruling other than a general grant of summary judgment. So she said the respondent's summary judgment
I
was
get
granted.
that, but can you answer my question?
Oh.
Are we left with looking at the second DCA opinion, period?
Well, to the extent it's not in the record, the other documents are in the record, you can't look obviously beyond that. But I think that what I can answer the question more fully is that the issue of collateral estoppel was not really ruled upon in this case at all. The Leon County Circuit Court entered an order prepared by the respondent, delegated to respondent, and it was entered whole cloth with no changes, including typos on page 2 and 3, including a misquote of the statute at issue in this case, and just signed. There were no findings, nothing. And those no findings include the collateral estoppel issue. About 60% or 80% of the order itself relates to collateral estoppel. It's just a pro forma declaration. The issues are the same as in the other case. But nobody identified what the issues were. Nobody identified specific issues.
Right, and that's your burden on appeal. Today, it's your burden. So we have no briefs from the second DCA. We have no other documents that you filed, so we're left with looking at the second DCA opinion. That's it.
Well, it was the respondent's burden for claiming collateral estoppel to prove that to the lower court, the Leon County Circuit Court. Leon County Circuit Court should have had evidence taken, information taken as to whether there was an issue that was raised in the other case. Nobody presented such an issue. There's simply just a declaration, there was another case, therefore the issues are the same. That's essentially what was raised. And the court
But didn't your client also move for summary judgment, which is to say that there were no issues of fact even on the state's
yes, and
affirmative defense?
the court denied her motion for summary judgment as well, yes.
But it was your position that there were no issues of fact in dispute regarding the collateral
Regarding the
estoppel?
unconstitutionality of the statute. Yes.
Regarding the collateral estoppel defense,
And
right?
Dr. Palin took the position that there was no collateral estoppel because the respondent had not raised any issues that were identical in the other case as are in this case. And even to this day, I believe they won't be able to tell you what issue was identical. And the second DCA opinion states specifically that absent a constitutional challenge, successful constitutional challenge, there wasn't anything they could do about the statute. That implies that no such constitutional issue was raised. And if no such constitutional issue was raised, it can't be identical to a claim in this case. If they're claiming something is effectively identical or basically the same thing, they didn't identify it. They didn't suggest it. And it's not in the court's order. The court made no findings stating, the following issues were raised in the other case, and the similar issues or identical issues in this case exist, and therefore there's collateral estoppel. There's 4 elements of collateral estoppel.
Mr. Husby,
Yes.
you have gone through your rebuttal time, but I know you
I
went through
apologize.
your rebuttal time by virtue of answering questions from this court. So, Madam Clerk, if you would add those 4 minutes back to rebuttal, also add 4 minutes to the appellee, if they're so inclined.
Would you prefer, Your Honors, that I continue or that I come back at rebuttal?
Are there other questions at this time? I think the better approach, Mr. Husby, is to make any other arguments during your rebuttal.
Okay, thank you.
Good morning. May it please the Court. My name is Sarah Hodges, and I represent the Department of Health in this matter. The Department asks that this Court affirm the trial court's order for 2 reasons. First, because collateral estoppel applies to bar this claim, and second, because Section 456.0635 sub 3 sub A sub 2 is constitutional. Turning to the first reason for affirmance. In 2016 administrative proceedings, the appellant alleged that the department unjustly applied this statute to bar the renewal of her license for 2 reasons: because it violated her procedural rights to due process, and because it served as a further penalty upon her license. However,
Ms. Hodges, you would agree a critical component of collateral estoppel is the identical issue must have been raised before, correct?
correct.
Was the constitutional issue raised before, or does the word constitutional appear in the second DCA opinion?
It does not. Rather, the appellant would use the word unjust. However, she made the exact same arguments in both of these proceedings, that the penalty was an excessive penalty outside of the disciplinary process, and that her procedural due process rights.
You would agree something can be unjust and not be unconstitutional.
Very much so, Your Honor.
The words matter, and you heard that from earlier, and the words I hear in every algorithm for collateral estoppel. I'm looking at an opinion I authored in Newberry Square, which was a 2020 first DCA case, but we keep seeing identical issues. So I just don't see how this is the identical issue that was in front of the second DCA based on the opinion.
Well, as Judge Thomas pointed out, when you look at that Second District Court of Appeal opinion, it is the same arguments that she has in her initial brief and her reply brief, and has argued before you in oral argument today.
Is same the same as identical?
In this case, I believe it is, and I think that changing the turn of phrase from unjust to unconstitutional does not then make these issues entirely different issues when the same arguments have been posed in both proceedings.
I understand the policy reasons. We don't want people serially bringing the same claims that perhaps could have been brought somewhere else, but specifically this trial court found this claim was barred by collateral estoppel. And that was the ruling, correct?
Correct.
And that's point 1 of your argument is collateral estoppel bars this. I'm just having trouble seeing a constitutional issue being raised in front of the second DCA. And you would agree with me that it was not raised.
That is correct. But even if this court were to find that collateral estoppel does not apply here, the claim that Section 456.0635 is unconstitutional is without merit. If we turn to this argument about the constitutionality.
Before you go to the constitutionality part, and it'll be interesting to talk about that too, but isn't there it seems to me at least, you can comment on that if I'm wrong, that there's a big difference between what we call, I guess, collateral estoppel and a 12068 judicial review proceeding, which is what the second DCA proceeding was, and hashing out in litigation and trial court in one case, having it become final, and then going in another case in a separate suit and trying to hash it out again. And typically, that's where collateral estoppel arises. I understand there's this judicial policy in place with respect to administrative proceedings, but isn't our approach different when we're looking at like an administrative appeal versus two separate pieces of litigation starting from scratch in a circuit court?
Well, in both cases, an administrative proceeding, one could also find that collateral estoppel bars that claim as well. So had she made these arguments only in administrative proceedings, then after that 2016 claim was barred, this one would have also been barred. I'm not sure I'm entirely understanding what you're asking.
Well, just we're trying to. It sounds like we're trying to treat what happened in the second DCA, which is the only place that a constitutional challenge could have happened in this case. Couldn't have happened before the department or the board.
Correct.
And so then we're left with it's a different animal though. So that ends up being more of a legal argument in what happened in the second DCA versus, hey, we've already hashed out this issue in litigation in the trial court in one case that went to conclusion, and they're trying to now bring it up again in a separate suit. To me, that just sounds a little bit different, but I don't know, maybe it's a distinction without a difference.
I would agree. I believe it is a distinction without a difference because of the fact that she's just couching the exact same arguments using different language.
Well, what if we looked at the same case and said, no, actually, we think it is unconstitutional? Are we bound by what the second DCA says on that? Well, let's say the second DCA looked at it and it's implicitly in their opinion, well, we think that this application is constitutional. So we get the case, we look at the same record and say, I don't know, that seems not so good.
This court would have the authority to make that decision.
Okay. But so then we wouldn't be barred. It's not a bar. It's more of a judicial policy. We shouldn't look at this again, or the trial court shouldn't have looked at this again.
I guess I was thinking of it in terms of yes. It is a bar. If this court decided that these issues were the same, then no, it cannot decide this issue that has been decided by the Second District Court of Appeal based on those same issues. That is what we are arguing today.
Of course, there could be a waiver of those arguments if you agree to transfer a venue, which occurred in this case, correct?
It did, correct. It did, which was also litigated at the Second District Court of Appeal, and that transfer of venue was affirmed by the First District. I'm sorry, it was this court.
So get into the taking everything as a given, what you just said. How is it that the trial court would be barred from entertaining a facial constitutional challenge to a statute based on what happened as an as-applied discussion or 12068 judicial review of an administrative proceeding?
Because of the fact this is the same argument.
But facial and as-applied are two different approaches to the same thing. I mean, they're just different. So how is it, one's a legal thing, is purely a legal question. And she would have to show in declaratory judgment action that beyond a reasonable doubt, there's no set of circumstances by which this statute would be constitutional. Presumably she could try and engage in that academic exercise. But that seems one level even further removed from what happened in the second DCA in the review of her actual application. She said that the denial of her renewal application was unjust.
Correct.
Well, that doesn't sound like a facial challenge.
She argued that the statute in the other proceeding, she had argued that it was an unjust statute and that it was unjustly applied to her. In both of these proceedings, the arguments have been the same and the language has just been different. She's just used a different term for something being unfair to her in both of these proceedings, which she considers to be unfair to her. When one is making a facial constitutional challenge, the movement must establish that no set of circumstances exist under which the statute could be valid. The appellant has failed to make that showing here. The statute bars license renewal for licensees who have been convicted of drug and fraud crimes. The renewal is barred for 10 years to ensure the safety of the public.
So then, do you disagree that every human being doesn't have or you disagree with the idea that every human being has a fundamental right to be a doctor?
Correct.
Okay.
Within the framework of this facial substantive due process challenge, the appellant argues that the non-renewal of licenses based on these types of convictions serves as a further penalty on these licenses. But the Second District Court of Appeal recognized, and as this court recognized, these are two entirely separate proceedings. Although the same conviction is used as a predicate in both of these types of proceedings, one of the proceedings focused on whether the conviction was a violation of the disciplinary statute, and the other proceeding, the renewal proceeding, focuses on whether the appellant meets the requirements for licensure.
What is the purpose behind expiring licenses, professional licenses, every 2 or 3 years and forcing an application for renewal? What is the purpose behind that?
To ensure that they still meet the requirements for licensure.
Right. Couldn't the board or that's different from just if someone actually messes up? There's
Correct.
Disciplinary avenues for that.
Correct. Those
So
are
there's
two separate proceedings.
Yeah, but it sounds so there's a separate purpose behind the expiration and renewal process.
Correct.
And is that just to force everyone to go through this and I guess to get their continuing education requirements and all that kind of stuff?
It just ensures that these professionals are fit to practice in this state.
Okay. And you
'Cause
still have.
I'm sorry.
No, go ahead, please.
I was going to say one could violate a disciplinary statute and the department would not necessarily be aware of it. So this is just a further assurance that public safety is protected.
And you have to meet whatever the requirements are every single time you.
Correct.
Renew. And do those renewal requirements change from time to time? So like I have my license and I've renewed it a couple times and then the legislature decides, hey, for now on, if you want to get a renewal, you have to do these other things as well. Can the legislature do that? Has it done it in the past?
I can't speak to it. I don't know for certain that they've done it, but I'm assuming that they have and that they could to ensure the safety of the public.
Right. I mean, you'd have to say that because
Yeah.
otherwise you'd be agreeing that everyone has a right to the renewal of their license as long as, I guess, I don't know what the exclusions would be for that, but okay. Thank you.
Of course. This limited non-renewal of her license did not serve as a sanction because as the Second District Court of Appeal found, it was not so disproportionate as to become a penalty. Because the appellant has failed to show that no set of circumstances exist under which the statute could be constitutionally applied, her facial challenge must fail. As to the appellant's as-applied argument, she alleges the statute is unconstitutional as applied to her because she completed a drug program and because her informal due process rights were violated. As to the drug program argument, it's important to note that the appellant failed to raise this argument in her complaint and first raised it at the motion for summary judgment hearing. But regardless, there are two glaring errors with this claim. First, the language of the statute does not permit renewal for any licensee who completes a drug program. Rather, the licensee must have entered into a plea which allowed for the withdrawal of that plea upon the successful completion of a court-ordered drug program. The appellant did not enter into a plea in this case. Second, there's no evidence in the record that the appellant actually did complete a drug program. Page 168 of the record contains a letter from an evaluator seemingly to the appellant's attorneys, finding that she did not have a drug problem and suggesting that she undergo 6 months of drug testing. Also in the record are records of that drug testing.
Is it even a formal hearing? I mean, it sounds like, on the face of the judgment and sentence, it's going to show that there's a conviction and it wasn't pursuant to a plea, in which case all the department or the department would have to look at is just the judgment and say, okay, we see that there's a third-degree felony conviction. We see that it was pursuant to a trial, not a plea. There's nothing else we can do.
That's exactly
Is that-
right. That is why her procedural due process argument fails in this case, because Section 120.57 only provides for a formal hearing where there are disputed issues of material fact. There were none here. She did not enter into a plea. She did not complete a court-ordered drug program. So there were no facts in dispute here, and so the informal hearing process was the proper process in this case. If this court has no further questions, the department would ask that you affirm because collateral estoppel bars this claim and because this statute is constitutional. Thank you.
Thank you, Your Honors. In rebuttal, I'd like to start with the issue of the purpose of the statute. The Department of State suggested that the purpose was to protect the public. And one of the arguments that we have made is that the interest of protecting the public really doesn't come into play, at least in this case, when you're talking about non-renewal based on precisely the same conviction that was the subject already of the disciplinary proceeding.
Wait, so are you making a substantive due process challenge to this statute?
Our initial brief includes substantive due process as well. Yes, Your Honor. That's
So
been,
you would have to, on that front, you'd have to establish that first of all, that it deprives her of a fundamental liberty interest, and then you'd have to show that the state didn't have a compelling state interest in regulating the medical profession and ensuring that convicted felons that engage in drug violations don't practice? Help me understand how you get, that's a long way to go. How do you get there?
Well, we have the fundamental right to as I mentioned before, to practice medicine. And also the fact is that there's not only the strict scrutiny test, which Your Honor is describing, but also the no.
I mean, I don't necessarily agree with you. I'm just trying to play out your theory.
No, I understand that, Your Honor. And what I was getting at here was that the public interest assessed or advanced by the Department of Health doesn't apply here, because the public interest is also being served by the disciplinary proceeding, which assessed a 2-year suspension based on that conviction, and not just based on that conviction, but based on a wholesale witness documentation, a wholesale evidentiary hearing to vet what would be appropriate in this particular case based on that charge, not merely based on a piece of paper. Then the piece of paper flows to the renewal process, and suddenly there's a 10-year bar. The lack of the unconstitutionality comes into play in part because your statutory scheme is having doctors take a case to trial thinking that their discipline will be their discipline, and then there's no defense if they get convicted and avail themselves of a jury trial. They're going to get a 10-year suspension, a 10-year bar to renewal,
right,
no matter what they do.
Because they're guilty.
But if they were guilty in that respect, Your Honor, there would be no renewal of the reinstatement of the license to begin with. The public interest apparently is served by allowing the physician to practice after the suspension is over. In this case, it was for a month, but it could conceivably be for 2 years.
Well, except that her license was going to expire by operation of statute. If she does nothing,
If she
the
didn't,
statute, her license expires.
certainly, but the public interest was served. She did something in this case, but certainly if she, upon expiration of the suspension, she was fully licensed to practice, and the public interest was served by allowing her to practice.
But doesn't it actually bear out what the state was arguing, is that this is why we have a separate expiration process, because sometimes this stuff gets missed, and so to make sure someone doesn't fall through the cracks, we make them reapply, which she did, and I don't understand what you think the department was supposed to do in the face of the statute that precludes the agency from renewing her license.
Well, the agency is suggesting that their hands are tied by the letter of the statute, but that's hence the constitutional challenge, because the statute itself is unconstitutional. And that dovetails back to what we were talking about earlier about the issues raised in the other case and the collateral estoppel
Mr.
issue.
Husby, and I know a lot of this was in response to questions. I'll give you about 30 more seconds, but
Okay.
you are through your time.
Okay, I do.
Just to conclude.
Okay, to conclude, Your Honor, I wanted to mention that there were many other issues that we raised, not just the two that the Department of Health indicated. We raised vagueness, overbreadth, the ambiguity of the statute, the lack of definition of the pretrial diversion statement or verbiage, the fact that Dr. Palin believed and alleged in this case that the drug program she did successfully complete, which demonstrated that she was not in any way impaired, and lifted an emergency a suspension of her license, that was sufficient to constitute a pretrial diversion. And the point I'd like to make, I know I don't have any real time left, but the fact is that that there are many other constitutional issues that we have raised, including that the non-renewal conflicts with and is not in harmony with the other provisions of the statute in terms of disciplinary action, and also that the suggestion that only that
Mr.
the
Husby, you've
done.
run through the 30 seconds. Thank
I
you
apologize,
both.
Your Honor. I have more to add, but
All right, we are now in recess.
All rise.